Before starting, I would like to request each one of you to mute yourself in order to avoid background noises. And I request the audience to be interactive throughout the session. And please drop all your questions in the chat box. Participants who are connected via YouTube Live can write their questions in the comment section.
If you want to fly, then give up everything that weighs you down. Good evening, everyone. This is Shikha.
And this is Archana Sharma.
And we welcome you all on the behalf of Entrepreneurship Cell of Kirori Mal College, Delhi University, on our event, Be Entrepreneur.
May I now take the honor to introduce one of the most prestigious cell of Kirori Mal College, Delhi University, to our audience. ENEUR firmly believes in producing entrepreneurs of tomorrow who will shape the world for the better and promises to be an amalgamation of innovation and leadership.
Now, moving forward, we are overjoyed to take this opportunity to introduce our speakers for today's session. So they are none other than Mr. Velandy Rajesh and Advocate Raghavendra Mehrotra. Mr. Velandy Rajesh is the managing partner of BizRights IP Partners LLP, which is one of the fastest growing organizations in legal lines. He has been awarded with the Pride of Hyderabad Award by Language and Cultural Department of Telangana, and also he is the knowledge partner for Telangana State Innovation Cell. His area of expertise includes corporate litigation, trade laws, and intellectual property laws.
And speaking about Advocate Raghavendra Mehrotra, he is the founder and managing partner of LAWKHART Legal. He is a strong legal professional with a bachelor's in law from Mumbai University, diploma in entrepreneurship and business laws from NUJS, and certificate in reviewing commercial contracts and certificate in IPR and trade law. He is skilled in criminal and civil litigation, trademark law, media law, and also legal document preparation and family law. Some of his most prominent clients include Airtel, Car24, and Jana Bank. Today, they will be educating us about legalities of a startup related to intellectual property rights. Now, I'd like to hand over the stage to Ms. Pooja to carry forward the discussion. Over to you, Pooja.
Thank you so much, Archana and Ishika, for giving me this opportunity. I'd like to thank the ECell of Kirori Mal College for organizing such a great event named DEBUT D Entrepreneur.
Good evening, Pooja ma'am.
Am I audible now?
Yeah, you're audible.
Yeah, you're audible. It's clear.
Thank you, Archana. Thank you, Ishika, for giving me such an opportunity to moderate such a great event. And I would like to thank the ECell of Kirori Mal College for organizing such a great event named Debut D Entrepreneur. I would like to welcome Advocate Raghavendra Mehrotra and Mr. Velandy Rajesh for this event. I couldn't give better introduction of both of you than Ishika and Archana. Thank you, Ishika and Archana, for that. So, how are you, Raghavendra sir?
Hello. Am I audible?
Yeah. Good evening, sir.
Good evening.
How are you, sir?
Good, great. And thanks for such a great introduction, Ms. Archana.
Thank you, sir, and welcome to the session.
Most welcome.
Good evening, Rajesh, sir. How are you?
Yeah, I'm doing great, Pooja, and thank you so much for a wonderful introduction. And it's a privilege to join with Mr. Advocate Raghavendra to sharing this platform. Thanks a lot.
So, before moving towards the session and the question, the main important thing when we listen about intellectual property is why the intellectual property is so crucial for startups. Like we have so many startups today with us. So I want to know that why is intellectual property protection is so crucial for startups. Please answer the question, Raghavendra sir.
Basically, I'll just start with a small introduction about what is IPR. So the full form of IPR is intellectual property rights. So it is something similar to whatever we do in respect of property. However, this in respect of IPR, it's a kind of intangible property in which we cannot see it, but it exists all around us. And with the development of time, the intellectual property right has become a very important part of all the corporates and businesses these days. So,
Right.
so basically, I'll just explain what kind of intellectual property rights and how are they distinguished basically into. So basically, an IPR or intellectual property rights are distinguished into 4 types. First is most important is a trademark. Trademark is something which we see the brand names and logos all around us. That gives the trademark gives a protection to them. So for example, we see McDonald's. The McDonald's, the logo and the thing that distinguish the McDonald's from other people, other brands. So that particular logo is called a trademark.
Right.
The second thing is a copyright, which is also a very important thing for all the corporates and for all the startups. It's a artistic representation or the way in which it is, what do you say, a description of the same thing is. So second is a copyright, and third is the most important thing, and which is very important for all a successful business, is a patent.
Right.
A great invention, innovative invention can give a boost to any kind of startups. If you have good amount of patents under your belt in the name of your organization, this will take you a next level altogether. And lastly, there is something called as trade secret, which is not has been codified somewhere, but it is also an important part of all the business organization. Every organization have their own trade secrets, which they are using and following since year together. However, there is no codified law, but the common law is followed in respect of the same all around the world.
I would like to ask Rajesh sir if he has something to add into it.
Yeah, I can add why IPR is important to any startup. See, every startup, they put a lot of effort and time, money to develop a brand or the product. Okay, until they register under their IPs, under trademark or patent, as Advocate Raghavendra said, industrial design, they can't own the, I mean, they cannot enjoy the ownership of it. Like example, you have a land, if you don't register, it doesn't have any value, right?
Right.
So you need to have a value means you need to own it first, right? That is one part. Another part is that I'll give an example of Flipkart, right? Flipkart, it is took over by Walmart for 16 billion, right? Out of 16 billion, 4.7 billion only for their trademark assets. Around 30% of deal goes on the IP. So imagine that you have Flipkart, suddenly they change the brand tomorrow to something else. Will you buy anything from Flipkart? This is the new brand, until you know that it is from the same company. Okay, so creating an IP is most important part for any startup, and they have to start working from the base, like identifying the IPs, like it can be a trademark, it can be a patent, or it can be an industrial design, anything as such. So it's very crucial for any startup to have their IP.
So as you told that everyone has to protect their IPR. So what are few mistakes that every startups make without any intention to it?
See, I'll just share a few of the examples what I come across doing our prosecution of applications. So many of the startups, see here one is when they start something new, there'll be definitely a financial support they look for. IP is not compulsion. So always the IP budget goes to backward to them. So what they do, they start investing on developing a product or a brand. After some time, after reaching some stage, they come to us for filing. I'll share you a story of a client. I don't want to name it, but now they're in shape now. They come up and the stage that they received an opposition from a UK-based company. So prior to that, what happened? They choose the brand without doing a proper search. They applied for trademark online without a proper support of a right attorney. And the process, they got a first round of funding from an investor, and they invested a lot to develop. When they supposed to get a second round of the funding, they received an opposition from a UK-based company based on the similarity grounds. So investor, they lost interest to invest on them because the brand is not in a stage of protection. Then they did a rebranding and they come out with a new brand. Then they came to us, we identified, we helped them to get a right brand, and we filed. Then the investor gained a confidence. Then they invested a second round of funding for the company. Right. So always we advise the startup of, okay, you're working on a brand or a product, identify, you do a search, proper study on its availability first, or choose a right brand, like choose a brand like Oyo, which is from on your own, or Cisco from San Francisco. There's no meaning in it, but you can find only one Oyo in the globe, or one Cisco in the globe, or one Amul in the globe. These are coined brands. So to have an exclusive rights or create a more value for the IP, the brand should be very unique and have an exclusive rights on it. Similarly for the other assets also. Hope I could able to answer your question.
Yeah, sir, absolutely. And Raghavendra sir, do you have anything to add to it?
Yes, rightly briefed by my learned friend. I just brief it in short. What usually we have observed is that a startup make huge investment towards other things, but they forget to make an investment or appoint a appropriate attorney in respect of IP. They feel that making other investments might help them to market their product more. But unfortunately, they appoint their friend or they appoint their relative to take care of the IP, having negligible knowledge about the implications of IPR, and they end up in trouble. So the most important thing, as my learned friend told, is the due diligence. The most important thing is the due diligence has to be appropriately done for starting it. Because you end up in a full, you pump up a lot of money, you take seed funding, and you do a lot of things. And after a few months or few years, you end up understanding that there are similar company existing somewhere else too. The most important thing that most of the startups do mistake in respect of IPR is the due diligence. They completely fail to do a particular due diligence. Secondly, according to me, they should know their competitors very well. Because the most crucial thing about a startup is being an innovative. Till the time when a startup is not an innovative thing, it won't last long. So the most important thing is to do a prior search in respect of IPR. Let it be trademark search or being a patent search. And third is what usually I observe is they copy their previous employer. So majority of them are coming from some kind of some kind of organizations coming from there and starting their own. But what we have observed that they try to enact what their employer were doing, but they don't understand that for some particular time they were under some kind of obligation and under some kind of contractual obligation with their employer. And once that comes into picture, they end up into bigger trouble. The more I have seen some organizations, some companies who have come with us at a baked away stage. And later on we get to know that they have copied the complete idea of their employer and they were forced to pay more than what they made right now. So I would suggest that you shouldn't copy your employer. Come up with an innovative idea, have a proper due diligence, and please invest some kind of money on the IP attorney along with making huge investment towards your marketing and other strategies too.
Right, so absolutely correct. So,
I would like to add one point here. Sorry. It's for a fun note. It's such a good experience for me. One of a startup, a young chappie approached me and he said that, sir, I want to register a brand. I coined a name kind of thing. And also he come out with a beautiful design of a fan. Then, yes, boss, we can go for it. I just asked him, what is the brand? He said that, sir, it should be very confidential. I worked a lot because my father into this he was a distributor for Bajaj fans for 10 years. And now I come out with a fan series with my own brand. So I'm thinking of keeping a brand Balaji Bajaj. So it's kind of okay. Then I said the complication what he get in, right? If you use a brand and of a Bajaj, then no, I said that you may make me a big richest man for taking up your case, but you lost whatever your father earned for last 10-15 years. Okay, so it's always better, to do a proper study, and as Advocate Raghavendra said, to reaching out a right IP attorney and get advice and move forward. Thank you. Sorry.
Yes, sir, absolutely correct. So, sir, as you told about the name, so what is the procedure for registration of name?
A trademark?
No, registration of name.
Yeah, name in the sense, yeah, the brand name you're talking about.
Yes, sir.
It's first we need to identify its availability. Okay, in trademark there are various categories. There are nearly around 45 categories. You need to reach out to a right attorney, or you can do a study. You need to specifically understand your business or what is the product you're going to deal with, and based on that you need to classify, and you need to do a check, proper check. It is not a basic Google search. Even the IP site is available. You can go and do a search. But if you go to a professional, we do check in various parameters. There are various grounds the trademark can receive an objection, like descriptive or there are various grounds. We analyze in those grounds, and we'll understand how strong is that brand to go for. It is good to go for, or it's better to change it or modify it, or let us avoid it. Okay, first we'll check the application, then we'll make a proper application for filing, and it can be processed. Do I need to explain the complete process, or?
Yes, sir, because we.
Okay, yeah, sure.
So, it would
so
be
the application has to be made properly. Like, we come across a lot of applications which are processed through online. In trademark, claiming the usage, if they're using a brand for a longer time or a shorter time, usage is very important. Claiming a usage is very important. They miss to mention in that. So here we need to make a proper application, and it has to be filed in trademark registry for specific jurisdiction. Now the online filing is available. You'll receive an application number. Then within 30 to 45 days, you receive an examination report. If any objection, the examiner raises an objection, we need to answer to it. We need to reply to the examination. If they accept, they publish in journal for 120 days. 90 days plus 30 days is a grace period. If they fail to convince, they call for a personal hearing. So during hearing, we will appear and we'll establish the fact of case, or we justify why we need this right. If they again convince, they publish in journal. During the publication, if no one opposed, they issue the registration certificate. So once you apply, you can start using T on top of a brand. If you are into service industry, you can use SM. In India, majority 90% they use TM only. Nothing wrong in it. It falls under Trademark Act. And after the registration, they can use R within the circle. It is valid for 10 years. Every 10 years, they have to renew it. And in trademark, various kind of application can be processed. You can apply for word to have an exclusive rights on the word what you have it. Or you can apply for a device, the logo or the visual presentation of your brand can be filed. And interestingly, the signature tune, like Britannia, Ting Ting Tidin, the tune is registered under sound mark. And packaging can be registered. So various aspects can be registered under Trademark Act.
And one question to you, Raghavendra sir. How do we know that if someone has taken our name and is using our name? How do we get to know that? And if that happens, then what are the options that are available to us?
Right. So see, as mentioned before, first you have, for example, once you receive the registration in respect of a trademark, there is every month there is a journal published, and in respect of a trademark registry, showing that the list of the trademarks which have been allowed by the trademark registry and which have been kept for publication. So let me just explain you the complete process in short. So once your trademark application is allowed, once you file a trademark application, it is kept before the trademark registry for the purpose of accepting it or disallowing it. Once the trademark registry allows your trademark application, it is kept for publication. So your trademark is published in the journal called Trademark Journal, in which it is kept for 4 months. So if any third party or if any competitor has any kind of objection to it, they can raise an opposition and everything. That's a different technicalities altogether in respect of litigation. So this is a trademark journal which is published every month. So for example, as an attorney, for every trademark, we keep a regular search whether any similar trademark has been applied in the trademark registry by keeping a regular tap on the trademark registry and the trademark journal. Along with that, in Mumbai and in other parts, they are anti-counterfeit team. We have a team of individuals depending on the kind of budget and everything. Like for example, in Mumbai, there are a lot of counterfeit product in respect of jockey or sports item and all. So we have a team which will give a public, will be going into the market and doing a survey. And if they found that similar counterfeit products are there, then we take out appropriate legal action. So now coming out, for example, once we have identified that Mr. X is using the product in a counterfeit way, or it is using our trademark, then there are several options with us. Firstly, if it's found to be a small organization, we can start with an issuing of legal notice to them. After issuing a legal notice, we can call upon them, that is called cease and desist notice, call upon them to restrict them from using their trademark and hand over the things and everything. So this is one of the simple way of stopping them to take ahead with the thing. That is issuing a legal notice. Even after issuing a legal notice, they don't restrain themselves, then we have to go ahead with the filing of a civil suit. That is called a restraining suit, in which we can claim for damages, along with we can get an injunction order against them so that they cannot use their products. Along with that, there is other remedy in the form of criminal remedy also, in which we can, but in that process, we have to take a prior permission from the trademark registry to go ahead with a criminal prosecution also. So these are basic 3 ways in which we can go ahead with the infringement process.
Okay.
In respect of trademark or any other IPR infringement.
Can I add one point? I felt it's very important for all the startups to move it. See, as per trademark, usage is a main criteria. If a brand is used in the market for a longer time, they can claim their rights. Okay, so claiming the usage is very, very important in trademark if they are using the brand into the market. And there are brands can be avoided, like, I said descriptive. Like you cannot choose a brand which is describing the nature of a product or service. Let's say example, I'm launching a packaged drinking water. I cannot brand it as a water or a drink. Okay, it cannot be registered. Or if I'm launching a TV, I cannot launch a brand with a smart TV kind of thing. So the descriptive can be avoided. Or if a brand already exists, so adding prefix or suffix. There are, I find a brand applied for Abibas instead of Adidas. Okay, Ray-Ban become Roy-Ban. Maybe he's from Bengal. Okay, those kind of, we cannot duplicate the name and apply for it. So choose a brand, as I said, try to come out with a name which is coined and unique in nature. So you'll have an easy registration process to get it. Thank you.
Right. Before moving forward, I'd like to say to the audience that please ask your question in the chat box so that we can take it at the end of the session. Thank you. So moving forward, I would like to ask Raghavendra sir that sir, because of COVID, we have switched to online mode. Many of the businesses have started their online transactions. So do you think that because of this online transaction on online businesses, it has discouraged or encouraged the IP rights?
No, I don't think so. The business going online will not make any difference in respect of an IPR right. Because whether the business is, because the IPR is something which is intangible. Even if you were doing a business before, physically the IPR presence was not seen to you, and even now you cannot see the IPR presence technically. So going offline or online will not make any difference. However, considering everything is going online now, even the trademark registry has become effectively online. They are accepting complete processes happening online. Even the hearing to an extent is happening online. So that has been an progress in the trademark registry in respect of everything going virtually.
Okay.
That's the minor difference that has taken place. Otherwise, IPR, there won't be any difference in respect of IPR.
And Rajesh, what do you think that what are some strategies which a startup can use for protection or exploitation of IPR?
Strategy, yeah. So basically, as informed before, the first basic strategy should be. So I'll just start. What should a startup do from scratch? So first and foremost, I think so, a startup should have a proper agreement executed with their team. Because we have seen a lot of dispute happening in respect of founders agreement. We have seen a lot of startups happening in the form of co-founders and founders. The first foremost thing I think should be in respect of IPR protection should be in the form of having a proper co-founder or a founder agreement in respect of a startup. Secondly, when we are going ahead with the registration or a brand name and a company name, it has to be properly searched. There should be a crucial strategy in selecting your name. As told friend, that the name has to be the most important name of a brand name. Should be a coin name, so that it shouldn't be overlapping with someone else, or you shouldn't feel that you have wasted your time and effort in marketing money, marketing on a brand name which was already existing before. The most important strategy, according to me, is first to have a detailed co-founder agreement in which the right between the founder and the co-founder has been described. I think so every one of you would have been heard about a taken place between, in respect of Facebook, Zuckerberg and his partner, in respect of the not having a detailed co-founder agreement. So usually, because according to me, you should have a detailed co-founder agreement, having a detail about the IPR rights, who will be having how much IPR rights, who will be funding how much, so that the startup is starting in a very clear manner, and once you're growing, there shouldn't be ambiguity between the partners or the name. Brand name has to be detailedly, you have to do a proper search in respect of that, and then go ahead with the registration of it. Thirdly, in respect of strategy point of view, once you're going ahead with your employments, you should have a proper agreement with all your employees. It being employer-employee agreement in which the IPR rights have been clearly mentioned that they cannot exploit it down the line. Second is a non-disclosure agreements. So certain agreements has to be properly executed between when you're starting a startup, so that as you're growing, the IPR is not compromised anywhere in any stage, because it's in India. In India, every second person ends up starting doing a startup. So it shouldn't be a case in which your idea has been launched by someone else or taken away by someone else. So these certain things, certain documentation are very crucial for all these startups, according to me. And most important thing, I always suggest all my clients that going ahead, if you're going ahead with any startup, go with an innovative patent idea. More patents you have, better IP rights you will be having down the line. I'll be just giving one example. I don't know whether you have heard about a Kingfisher brand or not. In the Kingfisher brand, if you have heard about that, they had taken 6,000 CR loan from SBI Bank just based on their IP. They had mortgaged their IP of Kingfisher and were able to take 6,000 CR from SBI Bank without mortgaging anything else. So that's the strength of an IPR for a company. More strength, more powerful your IP rights will be down the line. You can get a lot of funding just based on your IP rights. So I think so. This is the answer to your question. If anything specific, I can be more precise.
No, sir. Thank you so much for this answer. And Rajesh, sir, do you have anything to add to it?
I agree with the advocate Raghavendra for, legal binding with the way of agreements. Like you have a patent before disclosing to third party, sign an NDA first. Without signing an NDA, don't disclose your idea to anyone, even to your brother or friends. The first more thing. Always I suggest my client that give a templates of an NDA, fill the name and address, then sign, then you discuss about it, right? Because as per patent law, the applicant, date of application is most critical and crucial, right? So you discuss it with someone else today, and tomorrow if he file a patent, he is a rightful owner for the particular technology, not the inventor who struggled to develop it, right? So better have a proper agreement, as Advocate Raghavendra said. Second thing is that create more intellectual assets, the strategy point of encashing the IPR. Create more intellectual assets, protect them, encash them at the earliest, right? Like it can be a trademark, or it can be a patent, or it can be a industrial names, anything as such. I'll give you a value, like how important, how it plays a major role with an example of Motorola and Google. Okay, Motorola took over by Google for 12 billion, but actual company value was only 1 billion. But Motorola had 40,000 patent. As Google, they want to enter into telecommunication industry, so they thought, okay, those IPs are important from them. So they took over the Motorola for 12 billion, but the company value only for 1 billion. So rest of $11 billion is for the IPs what they hold it. Then after taking over, Google sold that Motorola to Lenovo. Only the company, the IPs assets are kept with them. All right. And another example I would like to give it, like how fast you want to encash your IP, because patent is valid for 20 years. Okay, after 20 years, it is going to be published, or it is going to be public. Okay, so like Intel example, Intel processor sold to given license to various companies like Dell, HP, or Acer, any other laptop or computer usage. So they sold the Intel process instead of 1,000 million, it's 10,000 million. Imagine that Intel, they launched one laptop with the brand Intel. They use it for only themselves. They would have reached the market so fast, right? So Intel have a practice of, if they want to launch after 10 years, they have a patent now itself.
Right.
Okay. So for I think there are a lot of engineering students there in the room. If you get a thought, or if you feel that there is a demand for that thought, if it is something novel, okay, don't wait for developing a product. You file a provisional application under patent law, you secure a date of the application. Then you have 12 complete months to file a complete specification. Okay, within 12 months, you develop a product and make a proper drafting, and then you can file it. Okay, so date of application for patent is most critical.
Right, sir.
Yeah.
And moving forward, we can take the audience question. So,
Pooja, I couldn't hear you. Your voice is very low.
Is it better now?
Yeah, it's better now. Yeah.
Yeah, so I was saying that we can move forward to audience question. So one question was there that this dairy has so many other brands literally copying its packaging and names too, similar to its own. Why isn't any action being taken by the company, or what action has been taken?
Can you come again, please? Sorry, I missed out.
Yeah, so someone has asked that why didn't this lady come up with some action or something, because their names and packaging has been copied a lot. So what do you have to say about this, Rajesh sir?
What I understood from your question, I'm just assuming that if somebody copy a packaging but the action is not taken. All right. See, it is kind of. I'll give some examples again. I'll always quote examples so it will be easy to communicate, right? Yeah, there are multiple huge amount of duplication of bigger brands in the market. Like example, ITC, they have like Clinic Plus shampoo, right? You may find some duplicates in the rural market, right? Instead of Clinic Plus, they change some spell in that, the packaging, everything will be the same, right? They do a business for some time until it reach to the distributor or the IP team of the ITC.
Right.
Once they get the information, they cheese, they arrest. It's a criminal offense. Okay, so they will not leave it. Some gap will be there, space will be that the information would have not reached to the IP department of the specific company.
Right.
Did I answer?
Yes, sir. So another question was asked by Shiv Charan. Raghavendra sir, please answer this question.
Yes, please.
He has asked that China launches and promotes the usage of imitated brand in its own country. So why there are no restrictions to it?
So basically, IP rights are restricted to a country. Every country has their own IP rights, basically. So, and as per my knowledge, there is even China has not signed to a treaty in respect of IP. So every country is under an obligation under a treaty signed by US veto, in which the patents and everything have been the part of it, and they're obliged to take care of each other. Or even sitting in India, you can apply for trademark registration for other countries. However, China, to the best of my knowledge, is not under any obligation under any treaty, and that's the correct. Rightly pointed out by the friend by that all the products have been infringed in China because they are not under any kind of legal obligation by anyone.
Right. Another interesting question came up just now. Ryan Zhan has asked that some startups fail to afford attorneys. So, what legal aids are available in that respect?
No. Can you come again? Sorry, I couldn't hear you.
Yeah, sir. He asked that some startups fail to afford attorneys. So, what legal aids are available in that respect?
Okay. You want to fight with an attorney?
No, sir. He's saying if you cannot afford an attorney, then what is the alternative solution that you have, right?
Yeah. I'll give you. I'm sorry. So I'm not sorry, Pooja. I couldn't hear you. I think your voice is very low. See here, under Startup Indian certificate, a scheme, the government supporting a lot for any IP, right? There are IP facilitator from the trademark or patent division. Okay, they charge very minimal on their professional costs. Even government is allowing a scheme like if you spend for an Indian, if you're filing a patent in India, they are reimbursing up to 2 lakhs rupees to an applicant, and if they are filing a foreign application, up to 10 lakhs rupees, the government is supporting it, reimbursing the money, like phase-wise. One initial stage of filing, 25%, and middle of publication stages, some 25%. That likewise they are giving it. So if you are a startup, please have Startup India registration and MSME registration. There is online filing. It's very simple. Okay, so you just go through and in IP website www.ipindia.nic.in, you have good amount of support from the government of India. Also, till 2018, the prosecution of applications are very slow. Okay, I remember when I started in the year 1998, to get an application number itself, I used to wait for 2 months or 3 months. The examination takes place for 18 months or 36 months. There are various cases. The registration take after 10 years. While renewal, the application got. When we get the registration, the renewal time has come. So now, after 2018, the Indian IP departments are super faster, and the applications are accepted in 17 days, 18 days, 30 days. Okay, the examination report issued within 30 days or maximum 45 days. So a lot of development in Indian IP. It is at par with the US. It's better than UK for patent. For UK patent prosecution take longer time. India, it's much better than UK. Okay, and also for supporting startup, there is an examination expedient process for examination report. Okay, but it is allowed for only 1,000 application per year if they have a valid Startup India registration certificate. So with that, you have an opportunity to grant your patent within 12 to 18 months. Okay, a lot of support from the government for IPs.
Right, sir. So one last question I'd like to pose it to Raghavendra, sir. So someone has asked that big companies can fight if someone copies their ideas or their packaging or name, but startups does not have so much fun and does not have so much time as well to go for such a lengthy process and fight for their protection of IP. So what can they do for this?
So see, in respect of a startup, first important, I know that startup doesn't have so much of funds to fight, but see, they have to protect it. They cannot dodge away from not protecting it on the pretext of saying that they don't have money for. As students and friends, there are a lot of aids available for startups and all, and even the courts have given a supportive view towards the organization for startups. And if someone is infringing your rights, it's better to approach the court expeditedly. So sometimes you wait for funds and you lose a lot of time. At that particular time, you are causing a lot of harm to your IP rights because they can claim a coexistence at that particular time. So, for example, you're using your brand for 5 years. You're a startup, and someone else is using the same brand for last 2 years or 3 years. Later on, after 5 to 6 years, you get a lot of funds and you go ahead prosecuting that person. He can always take a defense that I was existing in the market for last 3 years. So even I should be granted an opportunity to coexist, which is a very tedious or a problematic issue in kind of litigation. So in respect of litigation or in kind of infringement, it is better to act expeditedly. I know it might cost you a bit, but it would be a worth investment towards your protection of your IP rights.
Right, sir. So, because we have shortage of time, we can have one more question, I guess. So, someone has asked that please put some light on founder and co-founder agreements at the beginning of the venture, not only for IPR but in general life check in the company and all.
Surely. So see, let me start with things. The most important, once you start up a company, you have to select your organization. Which kind of organization you want to go ahead with. So let me explain you. Once you start a startup, you have 2 to 3 options which are available for you to go ahead with it. First is you can go ahead with a proprietary form if you don't have much of investment. Second is you can go for a partnership form. And third and most important, which is very important, it is a LLP or a company formation. If you go for a company or a LLP formation, getting an investment or funding is pretty easy compared to proprietor and partnership because the investors or are more interested to fund a company or a partnership or a LLP having more credibility. Because if you are a LLP or a partner or a company, you have more credibility in market because you are registered with the MCA and you have done all the compliance in respect of it. So that is the thing. In respect of founders agreement, in founder agreement, you jot down the scope of the profit and loss statement between the parties. What should be the IP distribution between both the partners or both the founders?
Right. Yeah. So
basically all the points, because drafting an founder agreement or a shareholder agreement is an extensive process, extensive thing in which both the mindset of both the partners have to be understood. In which what are the business ideas? Because the founder agreement or a shareholder agreement differ from organization to organization, because the some might have a patent, some might don't have a patent. What is the involvement of a particular founder in an organization, whether he'll be taking care of all the responsibilities or what kind of sharing of responsibilities will be there, whether they'll be sharing in respect of profit or whether they'll be sharing towards the billing. So there are a lot of things in respect of while drafting a shareholder agreement or a founder agreement that has to be considered.
Right, sir. So that was.
Can I add one point? I don't want to miss this point. Like, as Advocate Raghavendra rightly said, to interest of the investor, like what will happen that, okay, somebody is starting some project or a technology or a brand. To start with, they would have filed their brand on their personal name. Okay. But the investors will not show interest if the brand is registered on their personal name. Okay, if it is under the company, then only they put interest, because he is going to invest on the particular technology or the brand. All right, so it is always better to register under the legal entity. It can be a private limited or LLP to start with. All right, yeah, that point. I thought it's important to communicate.
Thank you so much, sir. And so this was it for this session. I guess all the questions of the audience has been answered. Over to you, Ishika and Archana.
Thank you, Pooja, for being such a good moderator. Also, I'd like to thank Rajesh sir and Raghavendra sir for being such a good speaker and sharing so insightful thoughts. So now, since we know that our speakers are falling short of time and most of the questions have been covered, I would like to call our president, Pranshu Goyal, to extend a vote of thanks.
Good evening, everyone. It's my privilege to propose today's vote of thanks. I, Pranchu, would like to thank our speakers, Mr. Velandy Rajesh and Advocate Raghavendra Mehrotra, for visiting and enlightening us with their knowledge. Today's session was full of knowledge and interesting things. It gave a deep insight into the topic and also revealed some interesting facts and real-life situations about what the brands and people are actually doing. I'm pretty sure this precious knowledge that you gave us will definitely help us in some or the other way, like if we start a venture of our own or we work in some other venture. Once again, I would like to thank Mr. Rajesh and Advocate Mehrotra for taking out time from their busy schedule and enlightening us with the knowledge. Thank you so much, sir. A special thanks goes to our principal, Professor Vibha Singh Chauhan ma'am, and our convener, Dr. Sameer Lama sir, for guiding us and helping us throughout in organizing this program. I want to thank the members of the cell who really worked hard to make this event successful, and also thank you to all the students present here for paying your attention and being such a good audience. Thank you, everyone. Thanks a lot for your time and patience.
So finally, on the behalf of ENEUR, I would like to express my appreciation to all the participants for taking out time from their